All right, welcome back to Breakfast Central. We're still looking at the case of Nnamdi Kanu and the court, of course, refusing to grant him bail. We're joined by constitutional lawyer Evans Ufeli. And I think our first question would be your reaction to exactly how the court handled this and the court's decision not to grant Mazi Nnamdi Kanu. A number of people have said that his rights are being infringed upon. So I want you to further share with us your thoughts on that.
Well, for not granting Nnamdi Kanu bail yesterday at the Federal High Court is a further violation of his fundamental rights. The Supreme Court had said initially when the order for a trial de novo, that the federal government actually, by their act, the extraordinary rendition followed by the act of going to invade his house while he was on bail, that led to his disappearance. And actually, it was an act of irresponsibility on the part of the federal government. And that the extraordinary rendition was also wrong and a violation of his fundamental rights. Okay. Having said all that, one would have expected that what a court should do, having brought a fresh motion for bail, is to grant him bail, because it is his constitutional right to be granted bail so that he can come for his matter from the house, from wherever he lives. But it is unfortunate that the court will descend so low to refuse him bail. We know that bail is at the discretion of the court, but that is at one level. The position of the Constitution is that, every person, every accused person, is presumed innocent until the contrary is proven. So at that level, bail is supposed to be the focal point at this juncture to grant him bail so that you restore the violation of his fundamental right, to restore him to the position where he was before the police, the soldiers invaded his home. He was already on bail in this same case, okay? He was already on bail in this case. That bail was revoked due to no fault of the defendant. And because it was revoked, when the Supreme Court had made clarifications on the issue, how be it that we had expected that he got the bail at that level. But now that they have reordered the trial, the court rather went into some jurisprudence of accelerated hearing, that it will rather not grant Nnamdi Kanu bail, but that will order for accelerated hearing to ensure that the matter is dispensed with expeditiously. But we know that our courts sometimes find it very difficult to dispense with cases quickly and expeditiously. So even when there's an order for accelerated hearing, it's still going to take a long time, because, this is the court of first instance that we're back to. Whatever outcome of this, parties on both sides may want to appeal, as we have seen before now, how they move from the Federal Court to the Court of Appeal and to the Supreme Court. So it is not the right procedure. The reasons given for not granting bail were not cogent. He is held, like the lawyer presented in the application for bail, that is having issues with his health, deteriorating health condition, and that the place where he's being kept is not good enough for a defendant or for the defendant. But the Constitution made elaborate protective provision for citizens who have been involved or are alleged to have committed an offense. The equal right that you exercise as a citizen who is not under trial is the same kind of right that a suspect who is not a defendant should exercise.
Yep.
Okay,
Right.
because the case is on both sides. Okay, so he's not supposed to go through all this. How be it that the case is politically orchestrated, it has a lot of strings and all that. The fact that the case has a lot of strings here and there does not mean the court should bypass the law and then to act wholesomely on the discretionary powers it has under the law.
It might be a good time to also just ask that. aside the legal perspectives, why do you think he's still being held? Because he's been, in police custody for at least, 5, 6 years now. Why is he still being held?
Yes, it's been held by the DSS, okay, and his health condition has deteriorated. He's being held unnecessarily. Perhaps they may give the reason that he's susceptible to jumping bail, or he's susceptible to not keeping to the terms and condition of bail. That has been the reasons they have given to the court, okay, citing the previous action that he left the country whilst he was on bail. But they also forget that he was on bail when the Nigerian army invaded his house, killed his family members, and for self-preservation, he left the country. He left the country. So, I mean, this is not to defend Nnamdi Kanu. This is to defend the law. That what the law says is what is superior. I don't have any interest in this case. I'm analyzing this dispassionately. That even if it were the other side that this was happening to, we would say that the position of the law is true, because the Constitution says that this Constitution is supreme and its provision to have a binding force on all persons and authority throughout the Federal Republic of Nigeria. So the Constitution is supreme and the Constitution have a provision in Section 35, okay, and 35 and 36. And under the constitutional safeguards, you all have these provisions that a suspect must be treated like a suspect, not like a criminal. Okay, so if you treat him like a suspect, then the rights that accrue to him as a suspect must be observed by the court and by the adverse party. Must be allowed.
You've talked about him being treated as a suspect and not a criminal. In his statement, he talked about how...
I said the Constitution have constitutional safeguards for suspects, and as such, he should be treated as a suspect as provided by the Constitution and not as a criminal. He's being treated as a criminal now, even when they have not commenced trial, he has not been convicted. All
right. So obviously, I mean, I'm sure you listened to the video where he shared how he's been treated whilst in the camp of the DSS. He's talked about not having had access to treatment. He talked about having congestive heart failure and the medication they're giving him not working. He's also talked about how he's not been able to access his lawyers to be able to walk through a proper defense. There are just a number of things that have been said. So what remedies does he have going forward if he's saying that he's not being he's not been given access to his constitutional rights? What are the remedies that the court provides, and how can these be implemented? That the law, provides.
The remedy that is open to him is for his lawyers to appeal that ruling. The application for bail that has been refused by the Federal High Court. His lawyers should go to the Court of Appeal and to bring that case before the Court of Appeal on appeal and make that demand for his release on bail by the court. Okay, that is the remedy open to him. That is the legal remedy open to him. Other remedies may be political and all that, which I don't want to deal with, looking at the law strictly. Okay, the case will go to appeal. I mean, in appeal, you have the argument re-argued there, whether or not he deserves bail in the case under reference, and whether or not it is the law that the suspect should be presumed as innocent until the contrary is proven. Okay, if you say a man jumps bail, you have to also look at the condition under which he jumped the bail. Did he jump bail willfully, or he was exercising his right under the law on bail when the federal government invaded his house? And if that led to his, by virtue of self-defense and self-preservation, he fled the scene, and in the process, his parents were killed. Family members were killed. What else should he have done? If you define that to mean he jumped bail, it means you are turning the law on its head, because you are the one who went to obstruct the course of trial. The federal government went to obstruct the course of trial because at the time he was on bail, trial was still ongoing. Trial was still pending. The case was still in court. So if you instigated his flee out of the country, should you turn around and say, approach the court and say he should not be granted bail because previously was granted bail and he jumped bail? That for me is not a proper legal reasoning. And for whatever reason the court have refused him bail, thank God is the court of first instance in the case under reference. There are still options of appeal under which he can actually ventilate his right as a citizen as prescribed by the Constitution to have bail as of right and not just as of privilege. How be it that bail is at the discretion of the court? The Constitution is supreme.
Okay. Quickly also share, I mean, a lot of people already would say that it's pretty obvious he would almost never get a fair trial here in Nigeria. The thoughts or the claims of granting him an accelerated trial, what does that even mean? For someone who has, constantly been, had his court case adjourned for years now. What does an accelerated trial even mean at this point for him? Quickly, please.
Well, accelerated trial, what it means under the law is what I will say. What it means under the law is that there's going to be speedy dispensation of the case. That means the court will not adjourn for too long, and the court will ensure that once witnesses are present in court, the court will go give the case priority to ensure that the matter is dispensed with early and a decision reached so that he can go have his rights under the law, either out of the court or whichever decision the court would have taken. But for someone that is having congested heart failure, for someone that is medically ill, for someone who is not being treated well in detention, and besides, it's not even supposed to be in the DSS custody, it's supposed to be at the Kuje prison. Okay, so I do not know why, because perhaps the case has to do with treason and terrorism, as they allege, as the court have alleged. But you see, all these allegations, none of these charges have been proven by the court, okay, by the prosecution. None of these charges have been proven by the prosecution. They are just mere charges referred against him. Anybody can be charged for anything. You can charge anybody for anything under the sun, okay? But you see, you will never get a conviction on any of the charges if you do not provide evidence to those charges, and such evidence must be so overwhelming. They must be proven beyond reasonable doubt, in which case you cannot inculpate the defendant. So none of this has happened, but it's already been treated as someone who is having jail time. And I think this is wrong. The international communities are watching. People all over the world it affects also how investors and those who want to have relationship with the country, internal and external relationship or international dimension. It depends how they also look at you. Your judicial system and the kind of decision reached in your court system have a lot of economic impact, okay, on the country. As if you
right.
He is agitating for secession.
Well,
okay,
we certainly want this to come to an end, and come to an end the right way, that the court does what it needs to do, and the rights of every human, especially in this case, the right of Nnamdi Kanu be maintained and not be infringed upon. We certainly will be waiting to see if his lawyers will appeal, and we look forward to having you join us again. Thank you so much for making our time to be with us this morning.
You're welcome. Thank you.